Hey folks, I'm attorney Roger P. Foley. Just driving to the office and wanting to talk about violations of probation. One of the most difficult things in regards to violations of probation is the burden of proof is basically the state has to prove a little more than 50% that you committed the crime. Obviously that's not very high, 50.01%, then they win. So how does the process work? Well, you have your first hearing, and at that hearing you have an opportunity to try to negotiate with the state attorney to admit or deny the allegation. So if you admit the violation, then you can negotiate a sentence with them. What happens when they want you to admit and they're offering you incarceration? Well, you can either accept that, which obviously most folks don't want to do, or you can deny it and then go to a final violation of probation hearing. And a final hearing usually takes about a month to 45 days to set. If you're in Broward, it's somewhere between 30 and 45 days. Palm Beach, usually the same thing. Well, what happens if you want to fight it? You have witnesses, you have a defense. It's inaccurate, the allegations that the probation officers made. Well, you can enter a denial, but in Broward County, you sit, meaning the judge doesn't give you a bond, meaning you sit in jail to have your day in court. Well, that stinks, right? Why? Because you have a job, you have family, you have obligations, you have financial obligations, and you can't do what is necessary if you're sitting in custody. You may lose your home, you may lose your job, all of the above. So one of the hardest things as a defense attorney is sometimes I can negotiate with the state to reinstate your probation if you admit the violation. But what if you really didn't do it? Well, if you really didn't do it and you admit to it, in effect you have an innocent man pleading guilty, and there's repercussions to it, because later on when you go to early term your probation, it may not be granted because you previously admitted to a violation of probation. And again, we're talking about a situation where you can admit and you're not even getting jail time. Maybe they're extending your probation. Maybe they're adding on some other conditions. Maybe they're putting on community control. Maybe you have to take some drug courses. Whatever the case may be, you're making an admission to the violation, which is noted on your record and it's there. So that's a tough situation. And I can't tell you how many times it's happened where my client has maintained his innocence, and if he admitted, I could get him out the same day. If he denied it, right, and held strong, well, he's going to sit in custody for about a month until we have the final violation. And the final violation, just because he has a defense, isn't a guarantee. If we lose, then he's definitely facing incarceration, the maximum amount of time of whatever the original charge is. So let's say you had a possession of cocaine. Well, on a violation of probation, you'd be facing 5 years prison on that if you lost the violation. So it's a very tricky situation. It's difficult, especially for me. If I'm thinking about clients who said, hey, Mr. Foley, I just want to admit, if you can get me reinstated, I'm good with that. And that's great, but I know that they're basically admitting something that, at least they've told me, they didn't do. And all I can do is believe my clients of what they share with me. So it's a tough situation. You get your day in court, but you don't get your day in court for about a month or two, or a month and 2 weeks, something like that usually. So that's violations of probation and one of the sticking points that you should know about. I'm attorney Roger P. Foley. You got questions, got a violation of probation, give me a call. Bye-bye.